Well, it seems that since April 30th, Michigan's governor has lacked constitutional authority to declare a state of emergency or a state of disaster based on the COVID-19 pandemic. So says the Michigan Supreme Court in its October 2nd, 2020 decision. In this video, I will explore the Michigan Supreme Court's decision. Also, stay tuned until the end for the Christian perspective. Christian attorney R.L. Johnson, lawforlife.us. If you are new to this channel, my aim is to make the law accessible to real people. So if you like the content, please be sure to subscribe and hit the notification bell so that you won't miss any new content. Now let's talk about the Michigan Supreme Court's recent decision concerning the governor of Michigan's COVID-19 executive orders. Now this case is entitled Michigan Institute of Health, PLLC versus Governor of Michigan. On May 12th of this year, the plaintiffs filed a lawsuit against Michigan's governor. The two plaintiffs are Michigan healthcare providers that were prohibited from performing non-essential procedures while the governor's executive order was in effect. And the second plaintiff is a patient who was prohibited from undergoing a knee replacement surgery due to the governor's executive order. Now, the plaintiffs filed this case in federal court in the Western District of Michigan as a civil rights case. They cited 42 U.S.C. 1983, which is a civil rights action claiming deprivation of rights, and 28 U.S.C. 1343, and for this they were seeking injunctive relief and attorney fees due to a deprivation of rights and/or injury. The lawsuit also appeals to the federal court's supplemental jurisdiction over certain state claims under 28 U.S.C. 1367. The plaintiffs argue that the protections under which the government leaders made their decisions back in March 2020 were grossly inaccurate. They also argue that, among other things, medical providers in Michigan are on the brink of financial ruin, facing extreme revenue shortages caused by the governor's order, forcing the postponement or cancellation of so-called non-essential procedures. In addition to that, they complain that thousands of healthcare workers across Michigan have been furloughed or laid off. The defendants in this case are the governor of Michigan, Gretchen Whitmer, the attorney general, Dana Nassel, and the director of Michigan's Department of Health and Human Services, Robert Gordon. So on October 2nd, at the request of the United States District Court for the Western District of Michigan, the Michigan Supreme Court resolved critical questions concerning the constitutional and legal authority of Michigan's governor to declare either a state of emergency or a state of disaster for more than 28 days without legislative approval. Consequently, in a scathing 59-page opinion, the Michigan Supreme Court held in a 4-3 ruling that the executive orders issued by the governor in response to the COVID-19 pandemic now lack any basis under Michigan law. So on what legal authority did the governor rely? In issuing her executive orders in response to the COVID-19 pandemic, the governor relied upon two Michigan statutes, the Emergency Management Act and the Emergency Powers of the Governor Act of 1945. In short, the Emergency Management Act provides in relevant part that the governor must, by executive order or proclamation, declare a state of disaster if she finds a disaster has occurred or a threat of disaster exists. However, the Act limits the duration of the declaration of the state of disaster to 28 days unless the governor requests an extension of the state of disaster for a specific number of days, which is then approved by a resolution of both houses of the legislature. Now, the Emergency Powers of the Governor Act provides that the governor may proclaim a state of emergency in case of a disaster, which includes things like rioting, catastrophe, or similar public emergency within the state, such that the public safety is imperiled. And this is done upon application of a mayor of a city, a sheriff of a county, or the commissioner of the Michigan State Police, or upon her own volition. The Michigan Supreme Court concluded that the governor lacked the authority after April 30th of this year to declare a state of emergency or a state of disaster under the Emergency Management Act on the basis of the COVID-19 pandemic. The court also concluded that the Emergency Powers of the Governor's Act itself violates Michigan's Constitution because it purports to delegate to the executive branch the legislative powers of state, including the state's plenary police powers. The court also said that the Emergency Powers Act, on its own terms, allows the exercise of such powers indefinitely. Consequently, the High Court said that the Emergency Powers of the Governor's Act cannot continue to provide a basis for the governor to exercise emergency powers. Now, interestingly, Michigan could have, but failed, to timely raise an 11th Amendment immunity defense when it was before the federal court. That is to say, before the matter was sent back to the Michigan Supreme Court for certification of those two issues. Had they done this before the federal court, they could have derailed this entire matter early on. That is to say, this case was filed appealing to certain federal claims, which are, together with immunities and other defenses, all governed by federal law. As such, the 11th Amendment, had it been pled timely by the state of Michigan, might have protected the governor from this lawsuit in federal court altogether. However, because Michigan was late in asserting its 11th Amendment immunity claim, the federal district court in this case denied Michigan's untimely assertion of governmental immunity, holding that the state waived such immunity by not timely raising it, either in their motion to dismiss the case altogether in the federal court or in their initial response to the court's invitation to brief the suitability of the certification question to the Michigan Supreme Court in the first place. The federal court also applied what's known as the abstention doctrine, which applies when a federal court has jurisdiction to hear a case. The federal court then declines to hear the case under the abstention doctrine out of respect for the state courts when the question, as is the case here, falls within a state court's jurisdiction. Now, Michigan has appealed that ruling by the federal court, and the matter remains pending in the United States Court of Appeals for the Sixth Circuit. Well, what's all this 11th Amendment stuff all about anyway? The 11th Amendment to the United States Constitution, which Michigan raised at the 11th hour, preserves the immunity of the state and bars lawsuits in federal courts that are filed by citizens against a state or the federal government. That said, this is the reason why, if Michigan had raised that defense early on, the federal court may have dismissed the case at the federal level. But because they did not do it timely, the federal court said that the issue had been waived. That said, it must be noted that an 11th Amendment analysis involves some of the most esoteric rules and confusing analyses in all of constitutional law. As such, in order to appreciate the 11th Amendment, we must turn not to what the 11th Amendment actually says, but what the United States Supreme Court says the 11th Amendment says. Incidentally, if you'd like to read more, I provide an 11th Amendment immunity analysis on my blog, lawforlife.us. With that in mind, here are the key 11th Amendment takeaways that you absolutely need to know to understand this case. First, the 11th Amendment only applies in federal court. You can't assert that claim in a state court. Second, a private citizen cannot sue a state or federal government entity in federal court. However, there are three exceptions. First, the 11th Amendment does not prevent the federal government from suing a state in a federal court. Second, Congress may, by making a plain and clear statement of its intention to do so, take away a state's 11th Amendment immunity protection under Section 5 of the 14th Amendment of the U.S. Constitution. And third, a state may, by making a plain and clear statement of its intent to do so, waive its 11th Amendment immunity protection. The third takeaway is this: there is a way for a private citizen to get around the government's 11th Amendment immunity protection. However, to do so, the citizen must do all of the following. First, the citizen can name a state officer as an individual, not as an officer of the state. For instance, if you believe that a state's attorney general, let's call him Edward Young for the purposes of this illustration, violated your federal rights, you sue Ed Young in his individual capacity, not as a state attorney general. Interestingly, plaintiffs sued all three of the defendants in their capacity as state officials, which also could have been fatal to the plaintiff's lawsuit. The second requirement is something known as authority stripping. That is to say, you allege in your complaint before the federal court that, let's say, Ed Young acted outside of his authority as attorney general by violating your federally protected rights. And the third component is that you allege that the state officer violated your federally protected rights, period. Well, why does all this matter? Well, it matters because one has to ask, how could the lawyers representing the state of Michigan have missed this obvious method of disposing of the plaintiff's case in federal court? So how was the governor of Michigan reacted to the court's decision? Well, when her lawyers were before the state Supreme Court, they maintained that the governor could terminate her executive order or reinstate it, thereby restarting the 28-day clock. Also, in her October 2nd press release, she continued to defend her over 180 COVID-19 executive orders on the theory that she took action to protect Michigan's residents. She said that the state Supreme Court's ruling could put the state at risk of more cases of COVID-19 and harm the state's economy more overall. She also maintained that her emergency declaration and other orders retained the force of law because the Michigan Supreme Court's opinion did not become effective for at least 21 days. That is, until Friday, October 23rd, 2020. Further, despite the fact that the Michigan Supreme Court ruled that the governor's post-April 30th executive orders lacked any basis under Michigan law, the governor said that some of her mandates will remain in effect because they were put in place by alternative sources of authority, whatever that means. Having said all of that, the governor then turned around and asked the Michigan Supreme Court to immediately reconsider and stay the effect of its October 2nd decision until after October 30th of this year, which the court did on October 12th when it denied the governor's application to stay the effect of the October 2nd opinion. But Michigan's High Court went even further by reversing an August 21st, 2020 Michigan Court of Appeals decision, which was brought by the Michigan House of Representatives against the governor. In short, the August 21st reversal clarifies that the emergency powers of the Governor's Act is incompatible with Michigan's Constitution, and therefore executive orders issued under that act are of no continuing legal effect, and the court made that order effective upon entry. So how is the governor's co-defendant, Michigan's Attorney General, responded to this decision? Well, 2 days after the court's ruling, Michigan's Attorney General said that her office will no longer enforce the governor's executive orders with criminal prosecution. She went on to say that her decision is not binding on other law enforcement agencies or state departments with independent enforcement authority. And how has Michigan's Republican-led legislature responded to the court's ruling? Well, the first thing you need to know is that the governor's use of emergency powers has been a matter of contentious legal fighting for months between her and the state legislature. That is to say, her interpretation of Michigan's Constitution has been questioned by the Republican-led legislature. Indeed, in May of this year, Republican lawmakers in Michigan refused to extend the governor's emergency declaration beyond the April 30th deadline, which is why, by the way, the governor has relied on the emergency powers of the Governor's Act to issue orders since April 30th. So it should come as no surprise that the Speaker of the Michigan House, Lee Chatfield, called the ruling a giant win for the state. And the Senate Majority Leader, Mike Shirkey, agreed but noted that the ruling does not change the need for personal responsibility. So what's been the response of law enforcement in Michigan? Well, even when the governor's emergency declaration had the force of law, at least 4 northern county sheriffs questioned some of the governor's restrictions as overstepping her executive authority, and they accused her of creating a vague framework of emergency laws that only confuse Michigan citizens. As for the governor's other co-defendant, the director of the State Department of Health and Human Services, he waited a whole 3 days after the Michigan Supreme Court ruling to issue an emergency epidemic order using a law that was established specifically in response to the avian flu or other viruses or diseases that are or may be spread through contact with animals. This emergency epidemic order was effective through October 30th of this year. I say was effective because on October 9th, the director replaced the emergency epidemic order with a more detailed gathering, prohibition, and face covering order, which is effective through October 30th of this year. Now, perhaps the gathering, prohibition, and face covering order fleshes out one of the governor's so-called alternative sources of authority, as it claims for itself, among other abilities, the power to limit attendance at certain gatherings, to impose capacity restrictions in certain public and private spaces, to impose capacity restrictions in government and private workspaces, to require face coverings at gatherings, to impose restrictions on restaurants and organized sporting events, and to criminalize disobedience with the order by declaring a violation of the order as a misdemeanor, punishable by imprisonment for not more than 6 months or a fine of not more than $200 or both. And the other power that it claims for itself is the ability to deem certain members of Michigan law enforcement as department representatives specifically authorized to investigate potential violations of this order. So while the Michigan Supreme Court's decision answered some questions, we're nonetheless left with at least 4 unanswered questions. First among them is the question of Michigan's state immunity defense, which the Western District of Michigan deemed waived because Michigan failed to raise the defense until the 11th hour. As I mentioned earlier, this question is now before the United States Court of Appeals for the Sixth Circuit. So we'll have to just wait and see what the Sixth Circuit has to say about Michigan's immunity defense. The second question is, what of the governor's so-called alternative sources of authority? Take, for instance, the State Department of Health and Human Services gathering, prohibition, and face covering order. The question is, will these orders also undergo court challenges? Third, unlike states and state officials sued in an official capacity, the United States Supreme Court has told us that municipalities are not protected by the 11th Amendment. So the question then becomes, what effect, if any, will the court's ruling in the Midwest case have on the several Michigan municipalities and counties that have issued local ordinances in response to the pandemic that are similar to the governor's executive orders? Will these counties also undergo legal challenges? That's the third question. And fourth and finally, of biggest interest to Michigan workers is how this ruling will affect the temporary expansion of unemployment benefits, which was effectuated under one of the governor's executive orders, and which the court says lack legal authority. If you'd like to read more about the legal ins and outs of this case, check out our article on our blog, lawfullife.us. However, if you're looking for a scientific perspective, I suggest that you watch this video, which I believe provides a slightly different view from the one that we get from the mainstream media. However, as to the Christian perspective, I direct your attention to the following, as it is written, "So do not fear, for I am with you. Do not be dismayed, for I am your God. I will strengthen you and help you. I will uphold you with my righteous right hand. Isaiah 41:10. And do not be anxious about anything, but in every situation, by prayer and petition, with thanksgiving, present your requests to God, and the peace of God, which transcends all understanding, will guard your heart and your minds in Christ Jesus. Philippians 4:6-7. Also, peace is what I leave you. It is my own peace that I give you. I do not give it as the world does. Do not be worried and upset. Do not be afraid. John 14:27. And last but not least, it is written that, for God has not given us a spirit of fear, but of power and love and of a sound mind. 2 Timothy 1:7. Thank you for watching. We will keep an eye on this issue as it continues to develop over the coming days. And in the meantime, I'd like to know what you think, so feel free to leave your comments. Also, let me know if you have questions or suggestions for future videos. And be sure to subscribe and hit the notification bell so that you won't miss any upcoming content. Incidentally, if you're looking for legal content that's accessible to real people, be sure to join us at lawfullife.us, where we profess the truth that without God we can do nothing. God bless.